Okay, so how do we address these issues? How can we write plainly and be concise? Well, being concise does not mean every sentence is the same length. You can vary your style of drafting. You can have shorter sentences, you can have longer sentences, and you can mix and match them in your assignments and legal documents. And experts tell us that our clear writing usually should have between 15 and 20 words per sentence. Let's say even up to 25. Alright, let's have a look at another example from a will and analyze it in terms of how concise and clear it is. I, Jane Edwards, give, devise, bequeath all of rest, residue and remainder of my property which I may own at the time of my death, real, personal and mixed, of whatsoever kind and wheresoever situated, including all property which I may acquire or to which I may become entitled after the execution of this will, in equal shares, absolutely and forever, to John Edwards, his wife, Michael Edwards, per capita, to any of them living 90 days after my death. This is paragraph taken from an actual will. How complex is that? It's quite complex, isn't it? According to Professor Tisma, this is a flood of convoluted and empty prose. Wheresoever situated, whatsoever kind, use of archaic language. What about all of rest, residue and the remainder of my property? Doesn't that already include personal and mixed property and land and anything? All includes all property. There was no reason to draft all rest, residue and remainder at all. So how do we redraft this particular clause in the will? Well, Professor Tisma suggests the following. I, Jane Edwards, give the rest of my property to John Edwards, his wife, and Michael Edwards in equal shares, if they survive me by at least 90 days. Okay, now I'd like you to turn your attention to the type of legal terminology, and the task will be really for us to simplify our phrases, and language wherever possible. And you can see on your screen now some example of how we can actually simplify our legal language using simpler phrases that are used in everyday life. On account of because, in view of the fact that, because, in instances in which, when. It is of importance, important, and so on. In many cases, often, owing to the fact that, because. You can see now how we have replaced a whole phrase with just one word on occasion. And this is something that you should practice. Here's some other examples of possibilities that we can use to use clearer and simple language. Instead of saying admonish, why don't we say tell? Corroborate. Some evidence corroborates police case. Well, supports the police case. Demeanor, behavior, discrepancy, difference, and so on. Why am I saying this? It's not going to be a problem in court for the judge to understand what you're saying. The problem will be experienced by your client, and it's the end user. You should really ensure, especially in communication with your client, that you use plain English and as simple language as possible. And these are some of the examples. The next rule and the next strategy that I would like you to consider is to use, not to be afraid to use pronouns such as I, we and you in your legal correspondence. Of course, this is quite important in a practical sense for you, because it is one of the requirements of assignment number 1. You will be asked to write a legal letter of advice to your client. And one of the strategies that we need to use when drafting letters to other parties is to be able to call our reader you, rather than to refer to them in the third person. And you can call your leader you no matter who they are, even if they are a high court judge, as long as the context of the rest of the letter shows that it is drafted in a respectful way. And always avoid addressing the person you are writing to in the third person. I'll give you an example. In courts we often use, we have these books, formal books called jury directions, and they used to be drafted in such a way that the judge will refer to the court in the third person and to the jury also in the third person. These are books that tell the jury how they can, what the law is and how they should consider the facts of the case. And this used to sound like this: ladies and gentlemen of the jury, the judge would talk to the jury. He would say, the court instructs the jury to deliver the verdict of guilty if the jury finds ABC. This is how they used to deliver jury directions in courts. The court instructs the jury. The jury is there, judge is here, and yet the judge is talking on behalf of the court in the third person. That sounds like going to a restaurant and saying to the waiter, the customer requests the waiter to bring him a cup of coffee. Referring to oneself as the customer, and the waiter you're talking to him in the third person. So how should the jury directions sound? Well, ladies and gentlemen of the jury, if you, the jury, establish A, B and C, then you should find the defendant guilty.